Hello everyone. So here's the fourth question. Who may authoritatively interpret the Constitution? Well, the answer to that relies on the answer to the question of whose document is it? The people of the states, as reflected more directly in their state constitutions, and then the states, or the people of the states, indirectly via the state representatives, as it reflects in the Constitution of the United States. As evidence of this, I think this is a really good quote from the Kentucky Resolutions of 1798, anonymously authored by Thomas Jefferson, who wrote this for Kentucky in response to the Alien and Sedition Acts. In it, it states that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, but that by compact, under the style and title of a Constitution for the United States, and of amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving, each state to itself, the residuary massive right to their own self-government, and that whensoever the general government assumes undelegated powers, its acts are void and of no force. That to this compact each state acceded as a state, and is an integral party. That this government, created by this compact, was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion, and not the Constitution, the measure of its powers. But that as in all other cases of compact among powers having no common judge, each party, the states, has an equal right to judge for itself, as well as of infractions as of the mode and measure of redress. So since the states, and by the way, if you look at the Articles of Confederation, the preamble is not we the people, but we, and it lists the states. Of course, the states answering more directly to the people. And by the way, Patrick Henry, he wrote a letter in which he said, the First Amendment I proposed, following the ratification of the U.S. Constitution by a very narrow margin in Virginia, was that an explicit declaration of each state's sovereignty. But that since the states created the federal government through the U.S. Constitution, they retain the authority to judge the terms of that agreement. And of course, it wouldn't stand to reason that the creature they created may be the sole arbiter of decisions, of the authority delegated to itself, of course. So the states themselves really are the authority on the U.S. Constitution, but that's really an indirect way of stating that the people, who are the ultimate authority and power of any government, have the ultimate say. Now, in terms of the federal government itself, within the structure itself, obviously each position comes with the duty to interpret the Constitution as relating to that office. But in terms of disagreements, it is, of course, the role of the judiciary to arbitrate. And of course, as it says in the Constitution, that the judicial power shall extend to all cases in law and equity arising under this Constitution. So how could the Supreme Court do that if it does not have an ability to interpret the Constitution? So that's a very short explanation on who may authoritatively interpret the Constitution. But just remember, the people are the ultimate authority, the individuals that make up society. And in terms of the U.S. Constitution, it is a compact between the states. So the state governments have an equal right to judge the compact that they agreed to.